Pojď.
Rules that are identifying the real ultimate and beneficial owner of entities, corporations, and to register them so that they are visible, they are known to the officials, to mainly prevent money laundering and other, let's say, crimes, white collar crimes, etc. So with me here today are, and I don't know if I should start alphabetically, but and we have made a rehearsal on the names, so let me please try to be correct. From Babic Partners, a partner of the law firm, Iva Basaric from Croatia. Hello and thank you, Iva. Then a senior attorney from Vasilev Partners, Zornica Vasilev. And also my great colleague with whom I'm coordinating and cooperating on a daily basis in our app, Anywhere Legal, and also Eros, Kristina Zatopkova, a lawyer, legal coordinator, and my great right hand in all of the international legal matters here in the Czech Republic and worldwide. And I would ask Kristina to slowly guide us in the ultimate beneficial owner registration as a topic, and then we will go to the practical issues. So Kristina, the word is yours, and thank you very much.
Wojciech. Thank you. So as you said, every corporation has to identify and then register their ultimate beneficial owner. And the purpose was also said. Why is that? And with the registration, you have to provide the relevant and complete information about the UBO. You have to go through this process on a regular basis because you have to verify or review the information you provided previously. And if there are some changes, you have to update it. For the updating or registration process, you have to provide a documentation. I think that everybody is quite familiar with that. But you have to provide the information about the company, the organizational structure. It's, I think, very appreciated and necessary. And also you have to explain, maybe in the structure, the nature of the ownership or control. Then you have to provide excerpts from commercial register. Then you have to provide the identification. ID details about the person who actually owns the company or controls it. Who is the beneficial owner? So it's like name, date of birth, address, etc. And it's quite sometimes complicated, ID card or passports of this person. That's quite it, let's say, but also the process can be challenging, and when it's like multiple layers of the company, and then you have to go through different countries, and you have to, and then you realize what you really need, so you have to go with the instructions and provide anything else.
It gets much more fun then, and that's
Yeah.
obviously what we are going to touch here as well today. Not just giving you a let's say more generic information about the ultimate beneficial ownership, but rather give you practical inputs on specific situations that are getting much more complex. Like, for example, when there is a trust there in the back, and Zornica will speak about it later on, or when you have got multiple layer structure being all across the world or Europe, or what if you have entities in every country in Europe and you want to take this as a project and really make sure that the registrations are always correct. But also, what happens if you don't have your UBO registered correctly? What are the implications of that? Why should you have it? Can you actually have a fine, etc., etc.? I will only, for the very beginning, say so that the ladies can then compare to their countries. That in the Czech Republic, if your structure is very simple and you are a Czech citizen, it can even happen that the registration is going to be done automatically. But that's very unusual and not very common thing when your clients or your companies are owned by natural persons or another entities from abroad. That's where you then have to go to the court or to the notary here in the Czech Republic. You have to pay a certain amount of money to make the registration. In the Czech Republic, we are somewhere around 100 euros at the notaries, and about twice as much if you go to the court. Then the information are being checked either by the notary or the court, and they are making sure that the registration is correct. You can either use the documentation that Christina has named, or in more complicated situations, it is also possible that you create some kind of affidavit confirming your structure and who is actually the ultimate beneficial owner. So I'm just saying this because what we like to do is to compare various countries in Europe to make sure that everyone understands that there are certain directives which then are implemented differently in various countries. And that's where always even a very seemingly boring thing like ultimate beneficial ownership becomes a lot of fun and also challenging. And that's why we are trying to give you the expertise on that. So I would like to ask Zornica if you could compare a little bit the specifics of Bulgarian reality, some of the practical issues, the price, the cost, what you have to do. Are there any specifics there, please?
Hello, everyone. My name is Zornica Vasiljeva. Thank you, Wojtek. Thank you to Aros International for the invitation and for organizing this interesting lab discussion. I believe that the UBO topic will always remain important for businesses, especially as it continues to develop over time. So I am happy to represent Vasiljeva Partners law firm located in Sofia, Bulgaria. The law firm provides services to corporate clients and to individuals, both in English, in French, in German, and Russian language, in a lot of areas and matters like litigation, employment, and other matters, of course, financial legal matters, and many others. So let's talk about the UBOs here in Bulgaria. Actually, companies could by themselves file the UBO registration and register the UBOs, but they don't do it. They prefer always to receive some help from the lawyers. The procedure is quite simple, but when the structure of the company is too complicated, then it is not that straightforward to find who the UBO is and to find all the documents that must be submitted to the register. So first of all, I should mention that here in Bulgaria is quite different than the other countries because we don't have a separate UBO registration. We don't have a separate UBO register. I mean, the ultimate beneficial owners are registered in the same register where the company is initially incorporated and registered. For example, for companies, this is of course the commercial register. So actually, the legal representatives of the company can freely access the register and make this separate process, but they usually prefer lawyers to do it. About the documents, yes, there is of course the ultimate beneficial owner declaration, and this declaration must be notarized. If it is signed by, of course, not in Bulgaria, then there must be apostille or translation by a sworn translator here in Bulgaria, and usually the lawyers are arranging this process and giving advice to the client on the execution of the documents. And of course, these are the lawyers who identify the UBO together with the client, together with the documents that the client provides, the corporate structure, the corporate chains. Sometimes we need to read some articles in order to define who is actually the beneficial owner, being the owner or the controlling person. And then we need to find out also the controlling companies and to ask the client for certificates for these companies from the relevant registers where these companies are incorporated and registered. And these certificates...
Sorry, may I pause you a little bit here? Is it actually so that, for example, if you have got one company in the middle, like between the company in Bulgaria and the ultimate beneficial owner is the natural person there. Let's say that there is a UK company in between. So what verification of the document is necessary there? Like can it be just printed out excerpt from the register there in UK, or does it have to be apostilled?
Yes, it must be apostille document, official document. And if it is from the UK, then it must be apostilled. If it is from the Czech Republic, it can be only with the signature of the register, because Bulgaria and the Czech Republic have between a treaty where the official documents from your country are also official here in Bulgaria. But we don't have such a treaty with, for example, the UK. So it must be apostilled, which is actually the bad news, because clients must collect, we must collect, and the clients must collect all these documents for the controlling entities. And these documents must also evidence who the legal representatives of the companies are, which is the tricky part, because sometimes these documents provided by the clients do not contain this information, and we must ask for some other documents to be provided so that the register check the legal representatives who are described in the UBO declaration that are the same into the documents that we provide. And here, what is the new one? Because now it's a little more different than before. In the past, the officials from the register did not dig deeply whether this UBO is really the UBO. They more wanted to see whether you had the declaration, whether it is signed by the legal representative of the Bulgarian company, whether it has a notary certification of the signature, whether it is apostilled if it's from the UK, whether the certificates for the controlling companies are in place, whether these certificates evidence who the legal representatives of the controlling entities are. But they did not really dig into whether really this is the beneficial owner. Now the legislation is quite different, and companies are required to provide documents evidencing that really this is the beneficial owner and why this is the beneficial owner. And sometimes this would make the process a little bit difficult, because sometimes it's not that easy to find the documents, or simply the client is not happy of giving these documents to the register, because once a document is filed to the Bulgarian commercial register, every person who has a qualified signature can register, download this document, and save it to its own computer and have it forever and view this document. So when the documents have some sensitive information that the client is not happy to be publicly available, it's not that easy to disclose the ultimate beneficial owner. I have some examples, but I don't know whether I should share them now or later.
Yeah, well, look, let's also give a word to Eva for a while, but I will then run a round of practical questions, short ones, where we will be comparing the countries one to one. So I think we will get to that there. Thank you very much for this intro. And Eva, can you please take it from there and compare also like this, thing about Bulgaria, because I know we spoke about Croatia not being that picky about like what you actually put there, but also tell us a little bit more about how it now works in Croatia, etc. And also please introduce yourself.
Certainly, thank you. Hi, everyone. My name is Eva Basaric, and I'm a partner at the law firm Babic & Partners. We are a Croatian law firm based in Zagreb, and we have been operating in the Croatian market for almost 30 years. We are a full-service corporate law firm, so basically we provide assistance mostly to companies with a wide range of activities, everything stemming from corporate and UBO registrations, obviously, to financing and employment, and merger and acquisitions has sort of been at the core of our practice, as well as competition law. So we cover different areas that are applicable to corporates doing business in Croatia, whether they are foreign companies or local subsidiaries of foreign companies. As you mentioned, when it comes to UBO registration, Croatia is a little bit more straightforward or less document intense than some other jurisdictions, as Bulgaria. First, I should say that we do have a separate authority that maintains the UBO registry. So the companies in Croatia are registered with commercial courts, but UBO registry is sort of centralized and is maintained by the Croatian Financial Agency. It was perhaps maybe an odd choice when they were establishing the registry back in 2019, but they sort of made the process pretty straightforward. So in Croatia, the filing is made on the basis of a pre-described form that has to be completed with the requested data. Typically, what companies will also do, especially if they have a more complex structure, is that they will also attach an ownership structure chart to the filing. And this is mostly because the structure needs to be sort of described within the filing. So you can either attach the ownership structure chart, which sort of paints a picture and maybe more clearly sort of defines who is playing which role in the structure and which company is owned by which. Whereas alternatively, you would need to describe it in the form in words. So, showing it as a chart is actually more beneficial for the authority and any party that would be scrutinizing the file. What doesn't happen in Croatia is that you don't need to file the supporting documents when you're making the UBO registration. Basically, the company needs to self-assess. Each company, when making the filing, needs to determine it's UBOs, and basically the UBO registry will register whatever the company files. On the other hand, there is an additional requirement for every company in Croatia to sort of maintain in its archives all the documents that they use to identify the UBOs, and sort of to elaborate on the process as to how they actually establish that particular individuals are UBOs. Those documents would typically be examined by the inspection if and when the inspection would come as part of perhaps a greater audit. So this is in jurisdiction of the Ministry of Finance and the financial inspections. So it could very easily be that the inspection is not coming particularly to look just at UBO registration, but maybe as a larger set of documents, a larger investigation into different filings that need to be made, UBO registry filings included, right? This is when the authority would actually look at the documents that have been gathered to establish who the UBO is. And at this point, if the inspection doesn't agree with the analysis that the company has made, they do have the authority to fine the company, and also to sort of request the company to correct its analysis and point out where the errors have been made in those analyses. So, on one hand, you do have a more straightforward and easier filing requirement, but also a lot of times, especially, international companies or companies with a more complex ownership structure will consult attorneys, because they know that behind this there is an inspection of what was actually filed. So a lot of times the companies will still use attorneys to help them out with the analysis. Obviously, if somebody has a pretty straightforward, there's one individual owning a company and that's it, then the filing is pretty easy for them to make on their own. But in majority of other cases, we've seen filings made through attorneys.
So it is possible to make it on your own, because we've identified with Christina that there are multiple countries in Europe where actually it's not even possible to do that, from the perspective that it's necessary to have a certain specific access to the system where only notaries or only attorneys, as say local regulated bodies, can actually do that. And if I understood correctly, Zornica, it's also possible in Bulgaria to do it yourself.
Yes. In Bulgaria, yes, every legal representative of a company can file any documents to the commercial register, including the UBO, including change of directives, change of address, change of the name of the company. Everything could be filed from the legal representative of the company, or
but it goes through the commercial court, if I understand correctly.
Yes, to the file of the company being in the register. So actually, when the attorneys of law are doing this, they are doing it on behalf of the legal representatives. But the directors can do it by themselves if they want to.
And same for Croatia, if I understand correctly.
Same for Croatia, yeah. The companies can also use an online form, an online access, if they have it with the financial agency, to do it online. But if it's done through attorneys, it's typically done with a physical filing, because it's unlikely that the attorneys will have access to companies' access.
Understand. And it's also always like more complicated, or usually more complicated.
Yes.
Case.
Yeah.
Okay. Let's now go to the the more specific cases. I know Zornica has been through a few, and we've been discussing them shortly. I remember one very specific one, so maybe let's start with that. And that is like, if we have fund or another entity that is known by the local legal regime, I would say, as the like intermediary or ultimate beneficial ownership. And then I know there were a few. So Dornica, if I may ask you to elaborate quickly for a while on this topic, and then we will see where it leads us.
On the topic with the trust.
Yeah, trust. Yeah, sorry, I was speaking about fund, but actually, yeah, I meant to trust. It's in various countries, because in Czech Republic, actually, a trust that is in the Czech language is the same like a fund. So it's called svěřenský fond. So that's why I said that word. Sorry.
Never mind. I understood. Okay, so we were talking about that actually now. Companies must really prove to the register that this is the ultimate beneficial owner, and sometimes it is not that straightforward. And the real life example that we recently had is related to a Bulgarian company whose shareholder was another company, and the shareholder of this other company was a natural person. So this is 100% ultimate beneficial owner according to the documents and to the information which is available in the registers. But it turned out that there is a trust agreement in place. And actually, the natural person who is registered as sole shareholder of the shares of the legal entity owning the Bulgarian entity is not the beneficial owner. It was only a trustee, and this person was holding the shares on behalf of the real beneficial owner, but the beneficial owner was not evident in the documents. And actually this person has transferred the ownership of the shares legally to another person who was evident in the certificates in the public, like the shareholder of the company. But between them, because of this trust agreement, actually the beneficial was another person. So in order to be correctly this ultimate beneficial owner disclosed to the Bulgarian register, this trust agreement had to be provided to the register, but it contains some information that the client is not happy to be publicly available. So we had to think of a workaround in order to file this registration and to make it registered. And our attorney, Alexander Juruk, who is a great creative attorney, always thinks of a lot of workarounds, thought of some declarations to be prepared on behalf of the trustee and the settlor of the trust, and they're both parties to declare that I am not the beneficial owner because I have a trust agreement with this person. And of course, the same declaration from the settlor, I am actually the beneficial owner because I have a trust agreement with the person you are seeing being registered as the sole shareholder. So also we made these declarations to be notarized so that the register to be sure that they're really signed by these natural persons. So now, finger crossed, because you're in the middle of this.
Okay, so not done yet.
So let's see, but we found some court decisions in similar situations here in Bulgaria where the parties were not happy showing their agreements, their special agreements to the register and declaring some circumstances to the register so that the registration is done. So this is a workaround that could be used in similar cases.
Shows beautifully how it can really get more complicated. Actually, this is exactly one of the topics where it sometimes really may look so simple in the beginning, but then you get to like real high level lawyer capabilities to make things right. Actually, this hinted two questions to me. First is very practical one. If you had to file the documents proving the background of this whole trust agreements and stuff with the commercial court, if I understand correctly, in Bulgaria, does it then become somewhere visible? Because, for example, in the Czech Republic, if you file something to this I don't know how to translate that, even like the documents database, let's say, of the commercial court, then these documents are actually becoming visible. So you can go to the portal called justice.cz, where you can go to this, documents of each company, and you will find all the board resolutions, notarial deeds, etc. to each company. But probably I'm not really sure if the client would be so happy that his trust agreement is visible somewhere online. Is it something that happens, or this is not public?
For Bulgaria?
Yeah, I mean, yeah. So, for example, in this case, you had to file the document to the court.
Yes. Well, first, it's not actually the court; it's the registry agency where the commercial register is held. But never mind.
Okay.
Yes, every single document that is filed with the register can be downloaded by any person who has qualified electronic signature, make a simple registration with the commercial register, enter with the register via the electronic signature. Then this person can download and review everything that has been filed to the commercial register. And sometimes if you, for example, don't know what the others do, how they do it, you can also check the files of some companies, what has been filed there. Yes, so it's fully available. And once the document, is there, it will be always there.
So Bulgaria, definitely not the country to hide.
No.
That's good to know. Well, this leads me to another question, which is a little bit similar to this, but like you have often these agreements that are in the, let's say, back end of the companies. For example, you've got some kind of shareholder structure of a company where potentially, in terms of the number of shares, and the how big the share of a shareholder is, does not necessarily have to be the decisive point, because there can be a shareholders agreement between the shareholders where potentially even a lower amount of shares can have some preferred rights, or there can be an agreement that for certain decisions there has to be also a agreement of each, or even the shareholder with a lower amount of shares, at least in the Czech Republic, can in certain things have the decision making right. And then obviously, how it is here, you would have to really prove, or there can also be a silent partnership, or stuff like that. So in Bulgaria, you would really have to probably present everything related to this, even the shareholders agreements, explaining, showing who's got the right for what. And I could actually download everything, even, for example, a shareholders agreement from this evidence. So do I understand it correctly, or how is it there?
Yes, you understand correctly. If the beneficial owner is actually somebody who is controlling the company because of this type of agreement, even it could be also a person who doesn't
even have a share. Yeah.
Yes, it's just controlling via other means, via other agreements or something else. Then this person should be disclosed as the ultimate beneficial owner, and you should provide documents evidencing why this is the beneficial owner, and these documents will be evidence to the public once they're filed. So if you don't want this to happen, you must have good lawyers to think forward how to.
Well, okay, we're not going there. Eva, is it the same there in Croatia with these things? Pick one of those, whatever you prefer.
So I would say, with document confidentiality and everything, obviously the very filing with the UBO registry is not a problem, because we don't have to file the documents. But I think where clients sort of face issues are when the banks are doing their KYC exercises with the clients, because banks, because of their own obligations under the law, will usually make very detailed requests to clients, requesting, in addition to commercial registry excerpts, requesting also a lot of other documents, articles of associations, agreements, based on which they can independently determine or confirm that the UBO is the person that's been disclosed to the bank. because they need to make their independent analysis under the law, right? A lot of times where this will be a specific issue is, for example, if you have local companies that are owned or shares are held by funds, like investment funds. As I'm sure you're all aware, investment funds are not really keen to disclose, and sometimes are prohibited by different agreements from disclosing information on their investors, and even the local company will not have that information, will not have particular agreements in place, etc. So what we've done in those situations is sort of twofold. We have definitely always argued with the banks to an extent that, certain information and certain agreements are just not relevant for KYC analysis, because, whether somebody is an investor or not doesn't really matter, because that person is not exercising any control, and as such could not be even regarded as a UBO. So trying to limit the number of documents that are delivered in the first place, just because, arguing that they are irrelevant for the analysis. And then another thing where there is a person that is controlling the company, but certain documents are confidential and are subject to non-disclosure agreements and similar. We have definitely tried finding alternatives that would satisfy the banks, but also satisfy the client. And usually we have managed to do this by, let's say, clients' attorneys in foreign jurisdiction providing particular affidavits, testifying, that the data that is provided is true and accurate based on their analysis and information disclosed to them. So this has been sort of a mid-level, right, mid-ground.
We've been there as well. I remember Liechtenstein, colleagues of mine helping us out with the same way. So
that's a good one.
You named a real interesting topic. That is one of the category why to do it and why to do it properly. But let me maybe take a look from a certain perspective. Does the bank in Croatia, and then I would also like to ask about Bulgaria, actually trust the registration within the registry there? Like, they just take a look and if it's fine, it's fine. No. Or they just don't care?
They will ask for a UBO registry excerpt. They will look at what is registered, but we have faced, on occasion, situations where the bank was initially not agreeing with the analysis, because what they still have to do is request a bunch of documents to come to their own independent realization. And, on occasions, at first, the bank sort of had alternative thinking as to who the UBO should be. In the end, we were always able to demonstrate that sort of the analysis that the client made and that we assisted the client with was correct. But they will ask for a large number of official documents so that they can independently determine who these persons are. And obviously that's easier in European jurisdictions where you have commercial registry excerpts where shareholders are registered with company registries. Less so maybe in some other jurisdictions, such as US, where you're really relying on internal company documents to evidence this information. And I think that's where, notarized and apostilled affidavits come into play.
So if I wanted to say that one of the reasons to really do it and do it properly at the beginning is to have it properly filed and registered, because then the banks will take a look there and you're good, that would not be true. It's rather about, you should really do this workout in the beginning properly, so that when the bank starts asking, you are ready for the questions. How is it in Bulgaria, Zornica?
Well, in Bulgaria, banks do not rely on the information from the register as well. They want to investigate the ultimate beneficial owner by themselves. Actually, according to the law, all the obliged entities, so the bank, accountants, notaries, lawyers, and etc., they're obliged to make their own assessment whether this is the beneficial owner and to verify their own assessment through reliable sources. So actually, sometimes they use the register as a source of verification, but they do prefer to do this by themselves. So they ask clients to provide corporate documents, to provide corporate structures, to provide information, questionnaires. Sometimes they look into the foreign registers, for example, the company's house. But sometimes they ask for documents to be apostilled and translated into Bulgarian to be provided. We've been in different situations because actually they have internal anti-money laundering procedures into any bank. So they follow these procedures and they ask the clients for any information and documents during the update of their KYC procedures. And I've been into a situation in which when the client came to us, the bank has blocked the accounts of the client because the KYC procedure was not correctly in a timely manner updated, because the bank wanted to the client to prove who the ultimate beneficial owner is and to provide a lot of certificates apostilled for all the companies part of the structure. While the structure was really complex, the companies were spread all over the world, and issuance of these documents was something that it cannot be done for a week or for 2 weeks. And the bank was not happy that the company had declared into the register that there is no ultimate beneficial owner and that this is a senior managing official who is the beneficial owner. They wanted to know who the real beneficial owner is. So we had to sit together with the lawyers from the bank together on the table, review together the whole structure of the company, articles of a lot of the companies in order to review how the control follows and the definition of ultimate beneficial owner, so that they are happy with that situation. Being the local manager, I don't remember whether it was actually in this example, the local manager, I think he was local director in the Bulgarian company and director in the company above the Bulgarian company, the sole shareholder of the Bulgarian company, but still it was a director. And so we had a happy ending, and the bank unblocked the funds, the accounts of the client, and the employees received their salaries at the end of the month.
Yeah.
Was, this situation. So it happens.
This was actually a thriller, but there was not a spoiler in the beginning saying that actually the employees were waiting for their wages. Then it really had to be like really interesting. Well, you probably didn't even mention that, but it's actually 3:42. So we are slowly approaching the last third of the discussion, the seminar. And yeah, I really feel that actually the topics are getting better. Let me just close slowly this part that we were speaking about, like, you know, why should we, and how properly should we do it, etc. By maybe a conclusion. So in Bulgaria or Croatia, even if you think that you will somehow, you know, do it a little bit more easy and simple and yourself, etc., and you might manage to, in Croatia, very easily, you know, explain what your structure is, and no one will really dig too deep into that. Or in Bulgaria, if you will manage to, you know, hide something, then still you will probably, if you mean it with your business, like, you know, honestly, you will still have to open a bank account and transfer money, and there you are still going to have problems. So it's really, like, I think it's very important, mainly if you are from international corporation, to really consult a lawyer at the very beginning, even before incorporating, I believe. maybe even speak about the structure before you set up the company in order to be well compliant and transparent from the UBO perspective. And there's one more thing I would add to this. Not opening the discussion on that, but just as a like, let's say, dots on the end of the sentence. That is, when you will be potentially asking for subsidies or any other state funds, there will be the same or even broader check on your background, on the UBO structure. Also I just went through this process in the Czech Republic on the potentially connected companies and subjects within your structure that even potentially form a group with you, and looking into them from the UBO perspective and other financial courses. I want to open one more topic. Christina, please get ready, because we've been letting you there for a while. We've been currently, or even are still recently, running through a more complex process with one of our clients who actually has their entities spread all around Europe. And so we just wanted to share with you a few, I would say, practical issues or things that we think are good to say aloud and to know, to prepare in case that you really want to take this properly and to cover your structure all around Europe as a bigger project. What are the tips and tricks, a few of them that you should do prior starting that, so that it doesn't take a year or two, but you can do it in a few weeks or at least months.
Oh yeah, yeah. We are actually in process of this, updating the UBO information all around the world, and it's quite challenging. It's not challenging only for us and our partners, but I think it also for our client. And the only tip and trick, I think, is that you have to be ready or able to provide the correct information and correct structure, because it's very challenging. What was said, there are different legal systems, different platforms or applications or whatever. There are language barriers. You have to have the documentation which should serve you as evidence has to be translated to the language of its country, and then you have to sometimes obtain locally recognized signatures or whatever. So I think that the only tip is to be prepared to everything, that everything can happen.
Well,
and
we didn't want to hear that.
Yeah, unfortunately, because even though you have the evidence for and you think that it's everything and it's correct and okay, then you have to be prepared to be asked for anything else, and you have to provide it, because there can be penalties or sanctions. So
maybe just to say some like positive approach to that. So
we can help you with that.
Yeah, I mean, okay. So prepare, let's say, a certain set of documents that you can imagine that you could possibly need, according to at least one of or two or three jurisdictions where you're planning to go. Have it ready and make sure that you dig into detail there. And then you will still get more questions.
Yeah, and I think that the most important is to have in order your organizational scheme, the structure. That's the most important, and our partners will help you with the following questions.
I would say call Christina because she knows exactly what to do now. But I think you just really have to gain your knowledge and experience with the real world doing it. Yep. Otherwise, it's really probably hard to prepare for that. Actually, this is something I was speaking about in the spot for this discussion. There is a situation where this client has actually the shares on a stock exchange, and that's a place where the share structure is changing on a floating basis, I would say. And this leads me to another practical questions, and I will open the round of the practical questions. Maybe if Christina would remember some of the jurisdictions where actually there is this biggest issue. There are jurisdictions where you actually on a daily basis or regular basis, you can always see the percentages of the shares within the structure of the company. And there it really becomes a problem if there is a share ownership structure changed on a regular basis, that you would potentially, because they even have it to not just the full number, but also, like the dozens of, behind the comma mark. And so it's like 38.5, for example, and you have to be correct there. So we've been dealing with the question, like, do we actually really have to, submit that on a daily basis, which would be nonsense, obviously. Do you, ladies, Iva, Zornica, have it like this in your country, like that you go to the percentages, or it's only about who's the UBO having the decision-making power, having the control?
In Bulgaria, if you have a listed company at the end of the corporate structure, first of all, companies must file the UBO declarations, because at the beginning people didn't know what to do. Some of them didn't file a UBO declaration at all. Others filed UBO declarations, but they declared the public company whose shares are traded on a regular market as ultimate beneficial owner, which is not really correct, because the beneficial owner must be always a natural person. And now what maybe the practice now more knows what to do. First of all, the UBO declaration must be filed to the register. Then the companies in the middle, the controlling entities who exercise direct or indirect control over the Bulgarian company, must be declared together with their legal representatives. And then when you come to the listed company, you should check whether this company the shares of this company are traded on a market. And if this market is listed on the list of the Bulgarian authority, the Bulgarian Financial Supervision Commission, because this authority has a list of the regular markets which have disclosure requirements on a European transparency level, and which are considered by the Commission as transparent. So you can review who the beneficial owner is and how the percentages are different all day when you use the relevant tools and not in the Bulgarian commercial register. So if the listed company has these shares on such a market, then in the UBO declaration, you just have to declare that this situation, and you're not obliged to find the ultimate beneficial owner. But if the market is not listed, then you should find the ultimate beneficial owner. And if there is no natural person to fall into the definition of ultimate beneficial owner, then you should disclose senior official, and this is it.
Okay, Iva, how's that in Croatia? Is it similar, or?
Somewhat similar. So I think that the difference here is mostly made between, whether the company itself is publicly traded, or whether a company, an ultimate owner entity is publicly traded. Obviously, if it's the company itself, then it makes things much easier, because then obviously, for example, the various obliged entities such as banks and attorneys are not even required to determine the UBOs in that case. But if the situation is different, and there's an ultimate entity somewhere in the ownership structure chain that's listed, then actually the company still does need to do the full analysis. Most often this will result in, because it's a publicly traded company at the end of the line, it'll result in the fact that there's no person that has controlling interest, and then the directors of the local entity will be registered as UBOs. But I think it's also worth mentioning here that under Croatian laws, there's also an obligation to update the UBO registry data within a relatively short deadline of only 30 days from the effective date of change. And basically the authority requires change if there's a change in any of the data that's been reported. For example, even a change somewhere within the structure, not even necessarily a change of the UBO, but a change in somewhere in the middle of the ownership structure, this still needs to get reported, and that usually arises as an issue, and there are a lot of late filings, or what is regarded as a late filing under the law, because sometimes the Croatian company will not even be aware that somewhere up the ownership change there has been a change in ownership, and we haven't faced an issue yet where a client had to defend itself against the late filing claims, but there's always an approach if in case there would be sort of a misdemeanor proceedings claiming before the courts that the company filed as soon as it was aware of the change. But obviously, even with consistently insisting on fresh information, which is exhausting in itself, but even if you do that, you are depending on your owner and their owners of actually giving you the information that you need for the filing.
Well, we have got last 6 minutes. I told you it's going to be running faster than you think. Let's try to run a quick round of answers. If you don't know, you don't know. People will then be able to find it out. The sanctions. I just quickly looked it up because I didn't know myself. We didn't have a client having a sanction. So in the Czech Republic, yes, it is a misdemeanor. If you don't have it correctly, you have to update on a regular basis, like almost immediately if there is any respective change. The fine is up to 20,000 euros. I will simplify. And also there's a suspension of voting rights and other sanctions like from this perspective. Can I maybe pass to Zornica to tell us Bulgarian?
Yeah, thank you. Here in Bulgaria, you have to update the UBO within 7 days as of the change. So it's important if you are dealing with a share purchase somewhere to think for the UBO and for the documents for the UBO, because if you don't fall into this, sanction is 2,000 euro. Think about 2,000 euro, which is not that big, but if one company if there is a sanction imposed on the company, then each month this sanction is reimposed until the right UBO is registered.
And is it considered a misdemeanor or like a criminal law?
Well, the
act,
criminal
let's
law, the criminal part is only if the person who has signed the declaration has declared untrue circumstances.
Well, then if it's not correct, but yeah, I understand there is a difference. And Eva, how is that with the sanctions? How big are they? And
yeah, so as I mentioned, it's a misdemeanor in Croatia, and there's a range of fines, but they can be imposed up to 46,500 euro for the company, and also almost up to 10,000 euro for the director or another responsible individual within the company. So it's also it's not just the company that's on the hook.
Okay, so then another practical thing about the costs with the registration. I think I told the Czech Republic once, let's say it's 100 or 200 euros, depends, passing it to Zornica.
Actually, here the application itself costs about 7 euro to the register. The notarization, apostille, lawyer fees, these are the fees who are more. But the registration itself, it's almost nothing.
Okay.
And there's no cost of registration in Croatian.
So you only have to pay to your advisors to do it properly.
Yeah.
Okay. Online access to the databases in Czech Republic. There's a separate database, evidence of ultimate beneficial owners. It's distinct from the commercial register. It's something else. It's under separate law, and you can access it online. And almost all of the information, but just the information, not the documents, you can access. Like anyone can do that. How about Bulgaria? I think we spoke shortly about that.
Well, part of the document, a part of the information which is registered is evident by anybody, the same, it's online. And the documents themselves, which have been filed to the register, they can be seen and downloaded by persons with qualified electronic signatures.
Iva?
Well, in Croatia, some of the information is publicly available, mostly the name and I think the month and the year of birth of the UBO, and then the reasons why this person is a UBO. So an explanation how they meet the criteria. That's publicly available. The full filing is available to courts and certain other institutions that are directly listed under the law.
Amazing. So it's 15:59 or 16:59 in Bulgaria.
Yes.
Thank you very much. It was great. I'm impressed by your knowledge, practical, deep knowledge. It's obvious that you've been going through these cases for a long time, and I think it's going to be really interesting for anyone who's now dealing with the issue to actually listen to this debate once it is relevant for them. With me, there was Zornica Vasileva, Iva Basaric, and Kristina Zatopkova. Ladies, thank you very much. We've used the time to the maximum. I cannot wait having another discussion with you. It was amazing. And yeah, anyone who wants to know more about the UBO registries in any of these countries or looking up for handling a bigger project all across the world or Europe, please feel free to contact the participants of these debates or contact us through Eros International or Eros websites. I'm Wojciech Sucharda, Chairman of Eros International, and it's been my pleasure to host this discussion. Have a nice day.
Thank you.
Bye-bye.